Welcome, everyone. Thank you for joining us. It is a beautiful afternoon in Vermont. We're having some very unfall-like weather in Vermont. It must be 65, 70 degrees out there. My name is Tim Doherty. I'm a partner at Downs, Racklin, and Martin in the litigation group, who does a significant amount of work in the healthcare space. And I'm joined today by my partner in the litigation group, Jennifer McDonald, who also does a tremendous amount of work in the healthcare space and for healthcare clients. We met with you and provided a presentation earlier in the year in some trends that we saw developing in the healthcare arena and legal issues related to the healthcare arena. And we thought it would be valuable to have a follow-up session today. I'm going to start off by talking a little bit about what Jennifer and I have seen developing with respect to the False Claims Act in the healthcare arena. And then I'm going to pass the proverbial mic over to Jennifer, and she's going to talk about the peer review privilege and some thoughts and some observations she has on that important area of the law for healthcare clients. So with that introduction, let's talk about the False Claims Act and what we have seen since we last spoke with you. Some general numbers to start with, I think, are valuable. 2021 saw a dramatic increase in the amount of enforcement action that was brought pursuant to the Federal False Claims Act. And let me put some specifics on that. The Department of Justice reported that $5.6 billion were recovered pursuant to False Claims Act lawsuits in 2021. That is more than double the amount of recovery dollars from 2020. In 2020, it was roughly $2.2 billion. And out of that $5.6 billion, roughly 90% of those recoveries took place against defendants in the healthcare industry or in the life science industry, just about $5 billion in recoveries. So that is a significant uptick and a significant amount of money that was recovered in these False Claims Act against healthcare related defendants. Now, keep in mind that $2.8 billion of that alone came from a single settlement, the Purdue Pharma settlement. But even setting the Purdue Pharma settlement aside, it's still a really, really significant amount. One of the things that I thought was really interesting in looking closely at these numbers from 2021 is that a really high percentage, 70% of those cases were government brought cases. In other words, direct enforcement actions pursuant to the False Claims Act by the United States Department of Justice, and only roughly 30% originated as qui tam suits brought by relators. And that is a significant change. In years past, the numbers skewed much more heavily toward qui tam originated cases. So what does that mean? It means that the Department of Justice itself is taking a greater initiative to begin these cases and follow them through the investigation and the trial and or settlement stage. And the Department of Justice has said as much. And indeed, it's signaled and indicated that a significant reason for its increase in government brought cases is its focus on in-house analytics. In comments last year at the Federal Bar Association's qui tam conference, the Principal Deputy Assistant Attorney General for the Civil Division, Brian Boynton, talked about DOJ's efforts to expand its own role in identifying and bringing cases directly rather than relying on the Ketam bar and relators. And he said, and I'm quoting, "Our sophisticated data analytics allows us to identify patterns across different types of healthcare providers, giving us a way to identify trends and extreme outliers." And he also said that this allowed the government to see where the highest risk physicians are located in each state and in each federal district, and allows the government to demonstrate and quantify sophisticated relationships, such as physicians offering controlled substances to patients who are likely to divert them. So that focus on in-house analytics has really allowed the DOJ to step up its own initiated enforcement actions, which doesn't mean to say, I don't mean to say that the Ketam relators bar hasn't contributed significantly as well, but that is a change, and that is a bit of a shift that we're seeing. What are we looking at in 2022? Well, we were seeing still, really, really high numbers of cases brought and money brought in as a result of those cases. In the first half of 2022, DOJ reported about $500 million in FCA case resolutions. So remains to be seen as we close out 2022, whether we'll approach that high water mark of $5.6 billion. But either way, we're talking about really, really robust False Claims Act enforcement in the healthcare space. So with that context in mind, what kind of cases are we seeing, and what do we predict we're going to see or can continue to see going forward? What kinds of False Claims Act cases is the government bringing or are private Ketam plaintiffs bringing? A couple of observations. One is the area of telehealth. We all know that as a result of the COVID pandemic and the policies that have changed as a result of the pandemic, that we have seen efforts to improve access to care, particularly through telehealth services. That, of course, that expansion and that policy shift has resulted in alleged abuses directly related to telehealth, and DOJ has targeted those abuses both criminally and civilly through the False Claims Act. So we expect to see a continued focus on telehealth-related services and potential False Claims Act enforcement in that arena. And there's been a number of settlements announced in that arena. Similarly, the Department of Justice has said and has proven through its actions that it will continue to focus on the Medicare Advantage program, also known as Medicare Part C. Medicare Part C is the government plan that provides a capitated amount of funding to private health insurance carriers for each patient enrolled in their plans. And those the amounts of those payments are adjusted based upon whether risk factors for the patients are present or absent. And the Department of Justice has really focused its attention on plans and providers that allegedly manipulate that risk adjustment process in order to increase payments. And we saw a very large settlement out in California in this arena. So the Department of Justice has said explicitly this is going to continue to be an area of focus, and we expect it to continue. Finally, as I think most folks in the healthcare industry are well aware by now, we expect to see a continued focus on False Claims Act cases that emanate from electronic health records and EHRs. The government and the Ketam bar has spent a great deal of time and energy developing both methods of factually investigating these cases, sorting out how these alleged schemes work, and then the case law related to enforcement. And we have seen a number of large settlements in this arena recently. There's a lot of cases out there, and we expect to continue to see EHR based FCA cases continue through the remainder of 2022 and on into 2023. In terms of other False Claims Act sort of developments, the False Claims Act Amendment of 2021, which was sponsored and introduced by Chuck Grassley, Senator Grassley, remains in committee, as far as I'm aware. Those practitioners will recall the 2016 United States Supreme Court decision about the False Claims Act called Escobar. Escobar raised the materiality standard for a False Claims Act to be cognizable, a false claim to be cognizable under the False Claims Act. The claim has to be material to the government's decision whether to pay the bill, to put it in colloquial terms. Escobar raised that standard a little bit, making a materiality defense a little bit easier. And this proposed amendment would adjust that and would say that the decision of the government either to forego a refund or to pay a claim despite knowing of the fraud or falsity in the claim itself will not be dispositive if it will not be a dispositive and a definitive defense to the False Claims Act case. Although that legislation hasn't moved forward, if it were enacted, it would make defending False Claims Act in some circumstances potentially more challenging, and it's something we're keeping a close eye on. Another issue we're keeping a close eye on here is the Polanski case, which is currently in front of the United States Supreme Court. The Polanski case is scheduled for oral argument. I think it's fully briefed, and it's scheduled for oral argument in December. The Supreme Court has taken up a circuit split on the question of whether or not the government has the authority to dismiss a False Claims Act lawsuit after it's declined to intervene, and what standard applies to that decision. It's a bit of a technical procedural issue, but it is of interest to practitioners in the False Claims Act space, and it could be a complicating factor for our clients in the healthcare industry that are facing False Claims Act lawsuits. So that's where we are. We expect generally, and I welcome Jennifer to weigh in, but we expect generally a continued increase in enforcement, False Claims Act enforcement by the government itself, a continued robust enforcement by the KTM bar, and we expect that the healthcare industry and the life science industry will continue to be a major focus, the major focus of these enforcement actions. As always, this is of interest to our potential clients and fellow practitioners, and we will continue to keep folks in the loop as these developments unfold. Jennifer.
Thank you, Tim. So thank you everyone for being here, and for those who are watching this later on, thank you again. I'm going to switch themes from an update as Tim was giving to going back to basics with the peer review privilege. Most people who are in the healthcare field are familiar with this privilege. It's a very essential and powerful tool that protects records reviewed during a peer review committee from discovery in an adverse proceeding. This is a statutory privilege. It comes from Title 26 of the Vermont statutes, Section 1443. Every state has something comparable to this. And to really narrow in, this focuses on discovery in a litigation or another adverse proceeding. So if you are in a litigation, every single one that I have been involved in, there are requests for documents that often bleed over into requests that for information that would have come up during what could be called a peer review committee. And we'll get into what a peer review committee is, and that's a statutory definition in a little bit. But this is essential for the medical field in order to continue to evaluate medical care, improve the quality of care following an adverse situation. So it really provides that essential protection, and it makes sure that hospitals, healthcare institutions, and other entities, and it's not limited to just healthcare institutions, can take a look at what happened without the fear that this information is going to be used in a subsequent litigation. So essential, again, for our clients and for our potential clients who are in the healthcare field. I'll say the courts that have evaluated this statute have really cautioned that it should be applied narrowly. I would say that so long as, although there may be a narrow application to this, so long as the formalities of the statute are applied and the evaluation occurs, the protections are very strong. And so the narrow application is more focused on, is this a peer review committee that took a look at it, not a narrow application in the litigation context. It's a very powerful tool for healthcare institutions. So again, the purpose is to evaluate and improve the quality of healthcare being provided. What is privileged really depends on whether this information was generated or discussed in the context of a peer review committee. So we'll get to the distinction between materials that are really original sources and are not covered by that privilege, and then materials that would be covered. The types of entities that are considered peer review committees are several, and I think you can kind of put these into 5 or 6 buckets. So first, the statute talks about the Vermont Professional Standards Review Organization. That's one. There is also the Vermont Program for Quality in Healthcare. That was designated by the Vermont legislature in 1988 as an independent, non-regulatory peer review committee. And the mission of that is to improve healthcare. And again, that's really an essential key when the courts are looking at, does something qualify as a peer review committee? And it really needs to have that essential mission of improving healthcare by evaluating the situation following an adverse event. Other situations that our peer review committee are committees or something comparable that would be established by an HMO or health maintenance organization in accordance with the statutory sections in Title 18. And then for most of our purposes, or my purposes, it's a committee or about either a state or local professional association that was formed to evaluate and improve healthcare, or a committee of a hospital or healthcare provider that was formed to evaluate and improve healthcare. This also includes committees formed by healthcare providers to evaluate whether health services were professionally indicated, whether healthcare services were performed in compliance with the applicable standard of medical care. And then finally, committees that are formed to determine whether the cost of healthcare rendered was reasonable under the circumstances by providers of the professional health services in that area. Those are the statutory entities that are considered. The courts have looked at really the purpose and policy and have applied peer review committee to other types of organizations, such as the Joint Commission on Accreditation of Healthcare Organization. This also qualifies under the court's rulings, and certainly other situations where organizations are being formed or committees are being formed by healthcare entities to evaluate care. So again, going back to the court indicates that this should be really narrowly applied, but they have shown a willingness to apply that outside the really kind of explicit organizations identified in the statute, so long as the mission is consistent with the statutory directive. So really key, what's included? Principally, the underlying medical information records are not privileged in the context of the committee. This peer review privilege is really distinct from the other healthcare protections that would apply, because once you get into a litigation, those typical healthcare HIPAA privileges are waived once lawsuits are filed. So the underlying information is not going to be immune from discovery. It's also not going to protect conversations that may arise in the ordinary course of business operations between two healthcare providers. So a conversation between staff and medical providers generally that talks about quality control, that's not going to meet the standards required to invoke this privilege. Original sources, that's medical records, original notes, call records, and other things written in the medical record are not going to be covered by the privilege. That's all going to be subject to the standard productions in a litigation. Certainly in certain situations, peer review committees will hear testimony or comments from individuals. That testimony and what was said at the peer review committee meeting is going to be protected, but that individual will still be able to testify or disclose the, again, underlying information that would be within his or her general knowledge. So they can't testify about what they talked about with the committee or what opinions they formed as a result of the committee meetings, but they can talk about generally what they knew based on the underlying situation. So again, what's included? Work product of the committees, communications regarding the investigation, any analysis and recommendations of the committee, the conclusions of the committees. This would include reviewing healthcare providers' charts. And then again, no person who's in attendance at the meeting will either be permitted or required to testify. So that's really important for the purpose of a privilege, in that if an individual is present at these peer review committees, they cannot unilaterally make the decision to reveal communications in a contested proceeding. The question kind of with privilege is always who is the holder of the privilege, and that gets a little complicated. And there are certainly situations in other privilege contexts, such as the attorney-client privilege, where, for example, a client may choose to waive the privilege, or there may be a waiver inadvertently for some other reason. The question has been raised, not frequently, but it does come up, whether this particular peer review privilege can be waived. There isn't any definitive ruling on this, but the kind of musings of the Supreme Court have suggested that the stronger, better argument would be that this is a privilege that no waiver is ever permissible. And that again gets to really the policy arguments for maintaining the confidentiality and privilege of this information, and also the statutory nature that, in the statute arguably makes that privilege a mandatory policy against disclosure for anyone involved in that peer review committee. So again, this is really kind of an essential tool for all healthcare institutions and for all individuals who are evaluating healthcare after an adverse event with the intent to improve the ability to provide healthcare in the future. It probably comes up and is invoked in every single litigation involving violations or allegations of violations of standard of care that I come into contact with. It is certainly something that we always use in responding to interrogatories. I think again, almost every interrogatory request that my healthcare clients have ever received have sought to discover this type of information. Some of them are more explicit. There are certainly discovery requests that come across my desk where the opposing party is specifically saying, produce all peer, documents generated by a peer review committee. That's an obvious one. It's a hard no. There should be no request ever for that information. But then sometimes requests are more subtle. And so this is a privilege that is always invoked in my practice when representing healthcare clients. And again, although the courts have cautioned a narrow application of it, certainly I would argue that there is a broad use for it in the context of litigation, given the significance of this. So it's an important thing to keep in mind. The key for my clients and for potential clients is to make sure that the procedural steps are followed in the statute to ensure the protection, that there is a formal peer review process, and that there's really a bright line between ordinary business discussions and documents, and then what happens later in a peer review process. So those are really the keys. Again, this is a back to basics reminder. It's something that comes up all the time. It's something that is continues to be litigated and fought over in the court system. Sometimes with the help of the court, and sometimes simply internally during the litigation process between the attorneys involved. So very much something that is at the top of my mind when I'm representing healthcare institutions. So again, I'll continue to monitor that. I don't expect any significant changes in this in the future, but it's certainly something to continue to brush up on and review the procedural steps to be, ensure that this can be invoked in all the necessary situations. Again, I want to thank everybody for joining us today. If you're watching this later on, thank you. In terms of questions, for those that are here today, Jolie can put our email addresses in the comments section. If you're watching this later on, you can reach out to Tim or I with any questions, comments, thoughts on this. Our emails are, you can go to our website, drm.com. You can certainly find us on LinkedIn. And we'll look forward to talking and providing updates to folks in the future. Thank you.